who have been impacted by the criminal justice system. Um, Prior to mid last year, this was mostly focused on policy work and community organizing. But they hired myself and a few other folks to start building out a legal aid program to help folks do this. Um, my background prior to working at Civil Survival is I ran a very similar program at the King County Bar Association, helping folks with issues that came up on their background checks, like vacating convictions or waiving LFOs. So I'm excited to share some of that knowledge with you folks today. I'm going to open up, share my screen here. I'm going to take some periodic breaks throughout this to answer questions in the chat and just to take a breather. I have done this presentation 20 times, but usually it's a 60-minute presentation. So there's some new info on here. It's going to be cover more ground. So bear with me if this is a little rocky in places because this is new to me. And presenting over Zoom is not nearly as fun and dynamic as presenting in person. So we'll just roll with it. If you have questions, put them in the chat. Zoom does a poor job of recording questions that go into the Q&A section. So if you put them in the chat, then I can refer back to them later. And I put my email address in the chat as well. It'll show up at the end. But part of my mandate through this work is to bring the level of knowledge up across the state about this type of work and how to do it well. So feel free to reach out to me after this presentation with any questions you might have. I'm happy to share really any resources I have, templates, what have you. But without further ado, let me talk to you about post-conviction work, specifically vacating convictions and waiving people's legal financial obligations. So here's what I'm going to be talking about today. This is a presentation that's slightly modified from usual, so there's going to be some extra stuff. First, I'm going to talk about vocabulary. If you're going to take one thing from this presentation, please take this. You may not necessarily run into a situation where you want to help someone how to vacate a conviction or LFOs. I include this section about vocabulary because I think one of the most valuable things I can share is just how to talk about these issues in a responsible and compassionate way. So this is why I start with this at the top. I'm going to talk about the types of folks who have these issues and how you'll help them. How a conviction becomes a barrier, kind of what the benefits of vacating convictions are. I'm going to talk about my program a little bit, the Reentry Legal Aid Project, and the work that I'm doing. The process for vacating convictions. Then we're going to break from that and talk about legal financial obligations, the court fines and fees that people get saddled with when they get convicted or charged with a crime. I'm going to talk about the process. I'm going to talk about the kind of ins and outs, some tips I have learned from doing this in practice. And then I'll save a bunch of time at the end for any questions I didn't get to during the presentation. So let's talk about vocabulary. I'm going to use this term a lot. It is not the perfect term. I'm not an expert on this by any means, but I'm going to talk about people with convictions. And the reason I talk about this is when I've given this presentation or a presentation similar to it, I've done it through a lot of different groups. Folks with convictions on their records who want to know how to do this work pro se, attorneys in a variety of contexts, both criminal law professionals and folks with zero criminal law experience, and also like software engineers was a presentation I did. One of the trickiest things is how do we talk about somebody who has come to you for help because they're not able to get a job because of something on their record. There are a lot of terms that get used, especially in the legal context. Defendant, offender, felon, prisoner, you name it. For 2 reasons, I use the term people with convictions on their records. Number one, and most importantly, this is the most compassionate way I've found to talk about this issue. People who are dealing with these issues, who have gone through the criminal justice system or been impacted by it, boy, they really hate to be called things like defender or a defendant or offender. That's extremely dehumanizing. It really does not get across the width and breadth of what that means in their life and how bad that can be. And number two, this is as close to an accurate term as I found to kind of cover these things. I will say I have helped folks who need records vacated who do not have convictions on their record. I'll talk about that a little bit later. Um, don't call people felons for one thing. Aside from it being dehumanizing, some of these folks, they don't have felonies. If you have a misdemeanor on your record, you're not a there's no term for that. These are people with convictions on their record, and you're trying to vacate them to remove those convictions from their background checks, from their records. Not a perfect term, but it is the best one I have found. The next one, this is a personal pet peeve of mine, so that's why I included in the presentation, is the term collateral consequences. Uh, if you do work in the criminal law field, you will hear this term used a lot. It is especially used by folks who, like defense attorneys, prosecutors, judges, folks who are steeped in this. The idea is that someone is charged with and convicted of shoplifting charge, theft in the third degree, maybe, and they get a judgment and sentence that says, okay, you spend a night in jail, you've got 3 months probation, and there's a $500 fine. Those are the consequences of that conviction. Those are part of the sentence. If as a result of that $500 fine, that goes into collections and a collection agency adds $200 of interest and the person's credit score drops and they can't get an apartment and they can't get a mortgage because their credit score is so low. All of that stuff is often referred to as collateral consequences, with the idea that, like, sure, the judgment and sentence says X, Y, and Z, but look at all this other stuff that happens. And there's a lot of discussion about, like, well, what can we do about collateral consequences? How do we deal with this problem? I hate this term because from the client's point of view, none of these are collateral. This is just the consequences of the judgment and sentence. This is the consequence of the conviction they got. There's nothing that separates their credit score dropping from the 6 months of probation, aside from that one, in theory, is not the criminal justice system people directly impacting them. There's just no difference. These are just the consequences of a conviction. And I want to add that as attorneys with just any experience doing anything in this field, none of this is a surprise, right? Knowing that somebody who owes money has their credit score down, that should not be surprising. That doesn't require specialized knowledge. So I just want to say, like, when we're talking about what happens when someone gets a conviction and there's a judgment and sentence, those are just consequences. And if we could remove this term from our discussions, that would be great. And I will put a little asterisk, which is that I've had immigration attorneys tell me that there is like a legal term, like this has meaning in the immigration context. I don't know anything about immigration law, so I'm just going to defer to them that there is a situation where this term is useful. But aside from that, these are just consequences. People who are actually suffering these issues, it's all just part of what happens to them. And the third vocab terms, this is the legal part of this discussion, is the difference between vacating convictions, expunging convictions, and sealing convictions. Or I guess vacating, expungement, and sealing of cases. This one's tricky because in Washington state, these three terms have very distinct and different legal terms and meanings. If you were to go to another state, if you were to Google search, hey, how do I get something off my background check? In a lot of other states and in a lot of other places, these three terms are interchangeable or very similar. Whereas in Washington state, we use our own scheme. These are totally different things. You will hear me talk about vacating convictions almost exclusively in this presentation, and I'll show you why in a second. So let's talk about that. What is vacating a conviction? What does that mean? When you vacate a conviction, that means you are filing a motion and asking for a court order that does a few things. One, if you get a conviction vacated, it will turn a guilty plea to a not guilty plea. It will turn a guilty charge to a not guilty charge. It will dismiss those charges. Most importantly for our work is it notifies Washington State Patrol to update the publicly available background check service that they maintain, and it tells them remove the record of this conviction from the basically from the public's view. Uh, Other background check companies, third party background check companies, the ones that employers and landlords use, largely rely on Washington State Patrol's records to be up to date. So updating on Washington State Patrol has a knock-on effect of removing this conviction from records generally. And the last thing it does is it gives the client a legal right to answer the question, do you have a conviction or have you been convicted of this charge? They're allowed to say, no, I don't have a conviction. I've never been convicted. This does not affect the court record in any way. I mean, it affects it in that there's now an order to vacate entered, but there are certain types of jobs, there are certain types of work you can do where those convictions still exist. The case docket is still publicly available. So vacating convictions often doesn't help folks who want to work in, let's say, law enforcement or in some sort of state or agency. Those organizations either have access to the court dockets directly or they use services that they get those. But for the vast majority of people, for the vast majority of employers, vacating conviction essentially removes it from their view. In other states, expunging a record or expungement means the same thing. In Washington state, that's not the case. Expungement in Washington state is a non-legal process where you ask Washington State Patrol to remove records of what they call non-conviction data, but what for most folks means either errors on the watch report, errors in this record, or uh, background check records that say someone's been arrested, which essentially are supposed to be removed automatically. So it again, it's a method of fixing errors on the Washington State Patrol's watch report. Also does not affect court records. It does not give your client a legal right to anything. Um, there's no legal process here. There is a form that you fill out on the State Patrol's that's available on the State Patrol's website, and you essentially say you made a mistake here. Please remove it. I will also say, having dealt with this issue a bunch of times, State Patrol will not remove anything unless they have to. So they have a big checklist on their website that says, here are the things we are willing to expunge. I've never seen them deviate from that list for a variety of reasons. And they, basically the only thing I've seen them remove or expunge is mistakes they've made. Doesn't come up very often. When it does, it's very easy to do. Usually somebody can do this themselves without legal help. And then the last category is sealing of a record. Now, this one's a little bit funny because most of my experience has been in King County where this is not an option. But in other counties and especially smaller municipal courts, this is apparently more likely to be available. When you seal a court record, you are filing a motion in order asking a judge to make the actual court records unavailable to the public. This is not actually, and to clarify, it's not just unavailable to the public, unavailable to anyone, including court personnel. It just essentially makes a stub out of the court docket and says, okay, no one else can see aside from that this was charged and here's the date. This invokes constitutional rules in Washington state where the judge has to weigh the public's right to access to documents versus the individual's interests in having this record sealed. And I found mostly in King County that you're not going to get over this hill. The sealing statute, which is GR 15, does say that if a record is vacated, that is a factor to include in whether to seal something. And what I found is that there are counties in this state where judges are willing to vacate and seal as sort of a batch, which removes it both from the Washington State Patrol's records and also removes it from other agencies from being able to access it, which is great. But your mileage may vary depending on which court you're in. Um, that is something you want to, if you're in a place where sealing is an option, which I generally say, like, you're gonna have to talk to somebody in that where you're filing this motion. That's great. The one thing I would say is don't seal a record without vacating it, because all that'll do is make it really hard to vacate it, and state patrol doesn't care if something's sealed. They're just going to leave that record on somebody's background report. So let's talk about who you'll help when you're doing this work. What does this look like from the client's point of view? And then I will move into kind of like what that looks like from the attorney's point of view. I'm going to jump through this because I know I've got a lot to cover, and I'm only going to show you one client hypothetical. This is based on a real client that I served back when I worked for the King County Bar Association. Amanda's a single mom. She has three children, aged 10, 5, and 3. The 5-year-old is a relative's child that she was in the process of adopting. I think she's since adopted her. She has 22 convictions on her watch report. She did when she came through the program. She had a theft in the third degree from 1994. She had a marijuana possession conviction from 2004, and she had 20 convictions for driving without a valid operator's license. Mostly over a course of a few years. I want to say from like 2000 to 2002, these were all in. And as you can imagine, with 22 convictions that would show up on her record, she was unable to find employment or housing. Now, I think it's important to highlight this hypothetical because a lot of folks will see this and go, well, she's got a really extensive record. But this is very, very common. What had happened for Amanda is she had traffic tickets that she was unable to pay. And as a result, her driver's license was suspended. But she had kids who were in daycare and she had a job that she needed to drive to. So as a result, she would get pulled over probably once every month or two, and charged and then convicted of driving with a suspended license. A charge that does not involve any jail time, um, but involved, I think, like a $500 fine at the time. So she owed just thousands and thousands of dollars in legal fines. She really had nothing she could do about it. She couldn't pay her traffic tickets, so she wasn't able to pay these fines, and she still had to drive to work. So she just kept racking these up year after, month after month for a couple years. Almost everything on her record was eligible to be vacated. Um, and most likely all these legal fines were eligible to be waived. But without an attorney to help her puzzle through this is an enormous project for somebody to do representing themselves, which is why it is so important that pro bono attorneys do this work, that we have folks who are able to do it. So now you've got Amanda's example of here's what somebody's record might look like. Well, how does that become a barrier? Here, I've mentioned this a few times, but this is what a Washington State Patrol watch report looks like. These are publicly available. If you have somebody's name and date of birth, you can go on Washington State Patrol's website and purchase one of these about for anybody you know for like $12, $11. You can see this is what the first page looks like. You've got some demographic information, and you've got this section down at the bottom that says conviction and or adverse finding summary. This person has one felony conviction for assault in the third degree. It's a Class C felony. There's a section here listed as disposition date. Sometimes, usually I'd say this is like sort of accurate. It's usually within the same year as when they were charged or convicted, but it's all of the records you're going to see are always kind of sketchy. What I'll say is if you've got somebody who's being denied employment or housing, they think it might be because of their record, try and get a watch report for them, because a lot of times what is available on their watch report will not match what you will find in the court dockets or any other research you do. And this is usually the information that's going out to employers or landlords. So knowing what's on here is the most important thing, because vacating stuff takes it off the watch report. Stuff that doesn't show up on the watch report, probably not a priority. Stuff that shows up on the watch report but doesn't show up in court dockets may be a huge priority to get fixed, but it might not show up anywhere else. And so this is what the second page of this looks like, just to give you kind of a complete picture. You can see over on the right hand side here, there is a little information about this conviction. The date of arrest was 5/20/2014. There's a case number. I can see it was in King County Superior Court, which means this was probably a felony. Um, Assault in the third degree. Here is the statute that's cited. Sometimes that's important to look up just to get a sense of what the charge is. But this actually lists out this was a Class C felony. There's something listed as a status date, which again is like could be the date of the judgment sentence, could be the date of being charged. Again, usually within a year, but it's never like perfectly accurate. And often the watch report doesn't show this, but this one says some details about the sentence. 4 days in jail, 12 months of community custody. Doesn't list any legal fines on here. That doesn't mean there weren't any. It's just what shows up on here is always a little questionable. Gives you sort of a gist of what's going on. And then I show this because it's just such a rarity. Most folks, if they come to you looking for help for post conviction issues, what they're going to say is, hey, I'm not getting a job because I have stuff on my record. And if you ask them, okay, well, how do what have you applied for? What's going on? Usually they're not going to know. And the reason they're not going to know is that employers don't often tell folks, oh, we're not hiring you because you have a conviction on your record we saw. They just don't get a call back. Even if they get a call back and it says, hey, we're sorry, they almost never going to actually see the record. This particular client, I had a client who sent me this, which I was like, wow, this is fascinating because I never get to see what the employer's end of things are. This person applied to work at Uber. Uber apparently, at least at that time, was using a program called Checker. And you can see it's consumer report requested by Uber, status consider. And if you go down to the report summary, it says the national criminal search and the county criminal search came back with something, says to consider. And as far as that client's point of view is, that just means don't hire this person. The employer sees this and goes, unless I don't have any other applicants, this person's just not getting a call back. If I remember correctly, I don't include this because there's a lot of like personal information on the next page. It actually said, assault in the third degree, some piece of detail from the watch report. But we can't assume that I don't know if the employer looked at or cared what the actual charge was. If it has details that says, oh, they took a plea agreement and it was dismissed, probably doesn't make a difference. My guess is it shows up on the watch report as anything that goes to checker as this person has a criminal record, and the employer says, I'm not going to hire them. It's just not worth the risk when I've got other applicants. Vacating a conviction removes it from the watch report, which removes it from checker, which lets this person get a job. I'm going to take just a 30 seconds here to look in the chat, see if there are any questions. I don't see anything, so I'm going to keep moving on. I'll take another break sort of at the sort of when I get into the legal process of vacating convictions, but feel free to ask questions in the chat or I'll save some time at the end. Again, this is a new presentation, so this may go really fast or really slow depending on how things go. So what's my program? So I work for Civil Survival, which is a project within the Public Defenders Association, which, to be clear, if you don't know, the Public Defenders Association does not do any public defense. It's just a bad name for the program. I work for the Reentry Legal Aid Project. So what I do is both directly represent folks who have, for example, records they need vacated, legal fines they need waived, any sort of post-conviction issue. I also do a lot of CLEs like this, both to do trainings for other legal aid programs like ELAP, but also to like larger firms or like corporate counsel groups that want to do pro bono work for me. So I'll assign out clients that we have come into Civil Survival out to volunteer attorneys for other firms, people who want to do the work. This is really, I like to stress this. This is really easy legal work, but the court process that I'll get into in a little bit is so inaccessible to folks that somebody representing themselves they're gonna have a nightmare trying to get through this process. And it's not because the paperwork's hard, it's because the process is a mess. Um, so it's really important to me that we have pro bono attorneys working on this, because until the process changes, most folks just aren't going to be able to do this work for themselves. So what do I do? First of all, I mentor and recruit volunteer attorneys and pair them with clients to vacate eligible conviction records. If you come through my program, I try and screen all of our clients and make sure that the convictions they have are probably eligible to vacate. I'm going to talk a little bit about what makes something eligible. So if you are doing this work for ELAP, or you have a client who just asks you, "Hey, can I vacate my convictions?" You're going to really want to think about, okay, are these likely eligible to vacate? Because there's some strict guidelines that I'm going to talk about in a minute. I research cases, I train volunteers, and I work with the clients and the attorneys and the courts. I'm currently sort of negotiating with King County District Court to make their process for post conviction work simpler, to try and make the process more accessible to pro se folks, so that they don't need pro bono attorneys necessarily. We're nowhere near that yet, so please help folks in that situation. But there are efforts being made, especially around King County and sort of the surrounding counties, to try and make this process less difficult, because it's also a lot of work for the prosecutors and the judges with the way it's set up now. And the third one, most importantly for the ELAB volunteers, is I want to make this process as easy and fast for attorneys as possible. So again, think of me as a resource. If you have questions about any of this work, or just, hey, who do I get in touch with? Do you have templates for waiving LFOs in this client's situation? Can you look this person up? Feel free to reach out to me, because from my point of view, the more attorneys we have who are knowledgeable in this, or just kind of know the basics, the easier it is, the more pressure that puts on the court system and state legislators to make things better and easier. If we have a lot of motions to vacate being filed, there's a lot more pressure to make the process simpler. So let's talk about what that process looks like. I mentioned before that only some convictions are eligible to vacate. Um, I'm not going to run through the details of exactly what the rules are and what the exceptions are. I'm going to cover this basically. I included in the materials today, and Macy has posted them in the chat, the Washington court forms, motions, and declarations for vacating felony convictions and vacating misdemeanor convictions. They're two different forms. Those are basically checklists on what makes something eligible, and they are meant for somebody representing themselves to basically fill out, I was convicted on this date of this with this conviction, and then you go down the list of things that would make that conviction ineligible. And if you get to the bottom without checking any of the ineligibility ones, then the conviction's eligible to vacate. So my advice is, I'm going to cover some of this so you get sort of a general sense of the rules. But if you have somebody in particular with a conviction coming forward and saying, "Hey, can I vacate this?" Get the checklist out and run down the list, because that's going to get through all the exceptions and all the tricky parts without having to try and imagine a hypothetical for that. So what makes something eligible to vacate? First of all, only certain types of convictions are eligible. Well, what are the certain types? Class A felonies, the most serious type of felonies, are not eligible. Most sex related offenses are not eligible, and any sort of serious violent offense is probably not going to be eligible to vacate. There's not like a clear rule on this. There's a statute that lists them all out. But what I generally say is, if it is a assault, it might be eligible. But if you start seeing it's an assault with a deadly weapon, or against a police officer, or any of these sort of additional factors, probably not eligible. And DUIs, not eligible. Generally speaking, what this means is DUIs and stuff you probably consider a serious offense is not going to be eligible. Anything that is a property crime, or something about driving, or in any sort of drug related charge, probably is going to be eligible. And that's 99.9% of all the convictions out there. The second eligibility requirement is that most or all of the obligations of the sentence have to be complete. Um, why do I say most? So let's say we're using that hypothetical of Amanda. She has a conviction, or somebody gets a conviction for shoplifting. They have 1 day in jail, 6 months of probation, and a $500 legal fine. Until those three things are complete, they're not eligible. They have to have completed all three, and then an amount of time needs to have passed. Now, the reason I say most obligations and not all obligations is a lot of folks might be in a position to have those legal fines that they still owe waived. And if that's the case, you can ask to have those fines waived and ask to vacate the conviction at the same time. And that actually is a lot of folks. This presentation will cover in a little bit legal fines and how to waive them and what that looks like. But just keep in mind when I'm looking at somebody's record, if I see, oh, they've got 6 convictions that are all low-level property crimes and some of them owe fines, they might be eligible. That's basically in my mind saying, okay, well, I need to look closer and see, are these waivable? If they are, maybe we can vacate them at the same time. Otherwise, all the other sentence obligations, they have to be complete. A number of years needs to have passed since completion. So if somebody needs to have done 6 months of probation, uh, the day after that probation's complete, now a timer started until they're eligible to vacate that particular conviction. Now, how long is that? There's some exceptions in these rules, but the gist of it is Class B felonies, the most serious type of crime that can be vacated, it's 10 years. For Class C felonies, it's 5 years. And for misdemeanors and gross misdemeanors, it's 3 years. There's some exceptions in there, but those are the rules of thumb, and that is going to cover the vast majority of situations. 10 years, 5 years, 3 years. They cannot have any recent convictions or pending charges. Now, this also works on a time scale and it works on the same one. So, if somebody has a conviction in the last 3 years, they're not eligible to vacate anything until 3 years have passed. If somebody has a conviction from 5 years ago, they're going to be eligible to vacate their misdemeanors, but not their Class C and Class B felonies. And if somebody has a conviction 9 years ago, 9 years and 364 days, they are not eligible to vacate Class B felonies, but they're eligible to vacate everything else. So, what does this mean in practical terms? If somebody has a conviction from 2018, when I look at their record, they're probably not eligible to vacate anything. If I start seeing convictions further back, more stuff could potentially be eligible. And the last thing is somebody's not eligible to vacate anything if they have any active restraining orders or open warrants. Basically, if there's anything in the court in process right now, they're probably not going to be eligible for anything. This one's kind of I call this one out in particular because can be tricky from a practical point of view. If somebody comes to you and says, "Oh, here's my record," and then you look and they have an open warrant, maybe they can get that warrant quashed. But if there's some sort of ongoing court proceeding, they're probably not eligible to vacate. The reason for that is purely practical, by the way. Somebody can't vacate if they have a recent conviction. So if it's possible they'll get a conviction, they're not going to be eligible to vacate. The reason that this is tricky is restraining orders and protection orders aren't that compatible with post conviction work. So most of the time it's not going to be an impact, but every so often I'll get somebody who either has a protection order. I had a client who had a protection order from 20 years ago that was of unlimited duration, which meant for that person, they just ineligible to vacate convictions off their record forever. And it didn't matter that the convictions were unrelated to the protection order. They're just out of luck. The other thing that I've had happen once or twice is somebody's like, oh, I have this possession charge from 10 years ago, this conviction, can I vacate it? And when I looked at their record, they had a anti-harassment order from their neighbor that they didn't get along with. And it's like, I'm sorry, these things are not related, but we need to wait 6 months till this anti-harassment order expires. Then you're eligible to vacate your conviction and we can go through that. Again, these are the things just to keep in the back of your mind as we go forward. But if you have somebody with an actual case in front of you, or if they have a conviction and they're like, I was convicted of driving with license suspended in 2005, you can use the checklist from the Washington Court Forms motion. That'll answer your question. The other thing is, when I'm looking at somebody's record, if I see from more than 10 years ago a bunch of low level convictions where they don't still owe money, guesses they're probably all eligible because it's been a long time, probably don't have anything that any sort of sentence requirements that's going to have lasted all this time, and they're low level stuff, they're probably eligible. So let's say you take on somebody. You have someone come to you who says, "Hey, I want to vacate my convictions, or I've got stuff on my background check." And you go, "Okay, I'm going to help you out. These look like they might be eligible. What's that process look like?" This is usually what I'm saying. Okay, if you volunteer for me, what does that process look like for a volunteer? Well, first of all, let me click through these check boxes. You're going to receive a case file from me that says we've gotten a copy of their watch report. I've pulled some information from the court dockets. Here's the client's name and info, and here's what I think might be eligible to vacate off their record. Then, you look through it, you ask any questions you might have, you go and meet with the client and say, "Hey, I'm your volunteer. I'm going to try and vacate these three convictions. I think they might be eligible. And maybe there's a fourth one on here where I'm not sure, but we can give it a try." You have them sign a representation agreement. Next thing you're going to do is you're going to draft the paperwork, which really it again, if you look at the motions, I'm going to go over them briefly here in a second. They're really straightforward. It takes me 10-15 minutes to fill out the paperwork because it's go down the checklist, and if you don't check the wrong things, you're set. uh, the reason I say communicate with the prosecutor is, like I mentioned before, a lot of the courts in Washington state just don't have a process set up for post conviction motions. They don't come up very often, and the legal process in the statute looks a lot like a civil motion. You're filling out paperwork, you're filing it, maybe there's a declaration, there's not a lot of notice requirements or much you have to do. And also, you're filing a criminal law motion on a case that may have been dormant 10, 20, 30 years. In a municipal court, a lot of times it's very common for me to look and see that the court record or the court documents have long since been destroyed before I'm filing this motion, which means courts aren't always set up to deal with these motions. And it really helps if you can get a chance to talk to the prosecutor and say, "Hey, I filled out this motion to vacate this charge from 10 years ago. Would you agree to a motion? Can you look it over?" A lot of times I'll find they will, and they'll be happy to do it. Or they'll say, "I won't agree to it, but I just won't object." Um, and the reason for that is this is just extra process for them. Getting them to agree to it or just giving them a heads up sometimes smooths this over, because I haven't seen a lot of motions like this before. Depends which court you're in, but it is good to just check in. Then you're going to file your documents with the court. You're going to serve them on the prosecutor. Most of the time, this is why I say communicate with the prosecutor. Most of the time, that means I email them a copy and they go, "Great, looks fine." And then here's where the real work is. Here's where folks representing themselves get bounced out of this process. You wait a bunch of time. I put here 4 to 6 weeks. I actually think courts have generally been getting better. That timeline's shortened, but you need to check in with the court probably once a week, maybe more than that, to just make sure that this process moves forward. If you need to set a hearing, you may need to set a hearing just to get somebody to look at this, even if the hearing is going to be a judge going, "Oh, what is this? Yeah, that's fine," and signing it. Rarely, I mean, extremely rarely do I get any sort of objection from the prosecutors doing a motion to vacate, or any sort of briefing or argument against me. The most complicated thing I get is usually a judge saying, "I don't understand. What is this? Why are you asking to vacate this?" So that is where pro se litigants get bounced out of this process, because they often are not able to get a judge's bailiff or a prosecutor on the phone as easily as you as an attorney will. That's just the unfortunate thing. And if you don't follow up, these things will fall right through the cracks. I use this example a lot in my presentations, but when I first started doing this work, I was still learning. So I was doing a lot of direct representation just to get get the feel for it. And I filed my first motion to vacate for a client in Seattle Municipal Court, and it was like an old, I forget what it was, theft charge probably. Filed it, went on to my work, waited a few days, and looked at the court docket website, and I was like, well, it's weird, nothing's happened. I haven't got heard anything from the clerk, haven't heard anything about from the prosecutor, nothing's been set. I'm thinking, maybe do I need to set a hearing, even though I don't think this is going to be objected to. Judge probably just sign it. So I called the court clerk's office at Seattle Municipal Court, and I said, hey, can you look this up for me? I filed this a few days ago, I haven't heard anything. Court clerk was really nice, looked it up for me and said, oh, I'm really glad you called, because I've looked this up. So the way it works in Seattle Municipal Court is when you file a motion in a criminal law case, it gets assigned to the courtroom and the judge from that case. It's the judge has sort of the purview over that case number. But because this conviction was from, whatever it was, 10, 15 years ago, it just got filed into a courtroom that was not in use anymore for a judge who'd retired like 10 years prior. And the court clerk told me, oh, I'm glad you called me, because if you hadn't, nothing was going to happen. It was just sitting in a queue that people no longer had access to or looked at. Uh, so by calling, they were like, oh, okay, we'll move this over to a courtroom that has a judge in it. We'll get this reassigned, and no problem. Let's get this vacated. But without doing that kind of follow up work and doing it regularly, these things will just disappear. There are a few courts that have like a system set up where that's not the case, but I'm going to tell you, just this is where the real work of this is. And then you're probably going to have a judge look it over, say, that sounds fine to me, sign this order to vacate. They're supposed to send a copy to the state patrol. I find that sometimes doesn't happen. So I always send a copy of the order to vacate to Washington State Patrol. And you're pretty much done. I usually wait a few weeks, call State Patrol and say, hey, did this get processed? And they go, yeah, it's vacated. It's off the record. And I go, okay, great. Tell the client, you can now tell people you don't have a conviction of this. You were not convicted of this. You don't have to tell employers. You're all set. I have a question from the chat. How many felony convictions can be vacated? How many misdemeanor convictions can be vacated? It's a good question. As of 2018, the rules for vacating convictions expanded, and the answer to that is any and all of them. Any and all of them that are eligible. There's no limitations on how many convictions can be vacated. There's only limitations on whether specific convictions are eligible. So if somebody has 30 convictions on their record and you look at them all and you go, oh, these all seem eligible, you can just go down the list, vacate them all, and it's going to take a while and there's a lot of paperwork involved. But you can get to the point where somebody just doesn't have a criminal background check anymore, which is the ideal. So that is also my recommendation. Try and vacate as many things as you can, and go down that list. So what does that process that I just laid out in the timeline look like? So I mentioned you're meeting with a client. This is to some extent for volunteers of my program, so I'm going to go through this pretty quick. But if you have any questions or I don't cover anything fully, just let me know. Here's the important things to do when you meet with your client. One, get a limited representation agreement, get something in writing. This has not come up as an issue for me yet, but I think it is important to note you're going to file a notice of appearance for this motion to vacate in a criminal law case. And it is important to make clear to the client and clear to the court that you're not this person's criminal law attorney for whatever else may be going on in their lives. I just stress it's important to say, I'm helping you to vacate these convictions, but if you get arrested, if you get pulled over and arrested over the weekend, probably not going to be the right attorney for you, because I just don't do that type of work. You need to get a criminal law attorney who's helping you on other stuff. You should develop rapport and use compassion. I know this seems obvious, but I know a lot of the folks I work with don't do any criminal law work. Folks who have been impacted by the criminal justice system, folks who have convictions on their record, folks who have a lot of convictions on their record, or have convictions on their record because of mental health issues or God knows what else. They have basically had exclusively bad experiences with attorneys, judges, court personnel across the board. They may have never talked to an attorney that has done anything except abuse them and be mean to them and do a bad job. And I say that because this is your opportunity when working with a client, because of the nature of the work, to be an example of a good attorney who cares about them and is doing work for them that they're going to appreciate. So it is really important that you develop rapport, you work to make sure that they understand what you're doing for them and why and how you're going to help them, kind of the extent of the work you're doing, what you're not going to do, and that you are a person they can come and talk to about this issue. Um, I will say also from the attorney's point of view, as a practical matter, this is the best thing you can do for yourself, because if you have a client who likes you or at least feels comfortable and trusts you, then you may get a phone call later while you're doing this work or you're waiting to vacate a conviction where somebody says, "Hey, just so you know, I got arrested on Friday, so I'm not going to be eligible for now. I have an open warrant on my case. You don't need to do anything else. Just wait." Knowing that is a lot better than waiting 4 to 6 weeks, harassing the judge to look at your order to get it signed, and then getting all the way up to the end and finding out, oh, something came up in the meantime I didn't know about. This was a waste of my time. I should have just waited. It's very important that you have that relationship with your client, and it's very important that you provide a good example of what an attorney can be and can do for them that they probably never experienced. And then the third one is to adapt to the client's circumstances. I mean, two things by this. One is you may have a client with limited English skills or with a disability that requires some sort of accessibility help. You should do that. It's part of being a compassionate attorney. The other thing I mean about adapting to a client's circumstances is, if you haven't gotten this from my presentation so far, the way criminal records impact somebody's employment or housing or their lives doesn't make a lot of logical sense. It is not necessarily that the most serious thing on their record is the thing that comes up when they are applying for a job. Their watch report may not match what's in the court docket, or vice versa. They may get collection notices from fines that they owe or that they don't owe or that they've paid or who knows what. The record system, the way courts in Washington state handle all this stuff, is not clean and logical. So the person who's going to be in the best position to tell you what work to do and what is having the most impact on their life is the client. So if you see somebody who's got 20 convictions on their record and you want to help them out, ask them which records they want you to start with. Maybe they don't know. Maybe you just pick the most serious one or the courts that you know are going to be the fastest. But I would take the client's point of view because they're going to know what's helpful to them. They're going to know what's important. And ultimately, your job is to serve their needs. So there's a copy of this misdemeanor form in the chat. This is the Washington Court Form's motion and declaration to vacate a misdemeanor. Uh, I have done this work in a variety of courts and jurisdictions and counties, and without fail, everything I've been told every time is just use the Washington Court Form's uh, forms motion, except some really rare circumstances where I file this and then the judge says no because of some situation. I exclusively file these. I tell everyone just stick to the Washington court forms. That's all you need. Don't don't deviate from this. The reason for that, more than anything, is that if you end up in a municipal court where the prosecutor or the judge has not seen a motion to vacate before, they're going to feel much more comfortable looking at a Washington approved form than whatever you draft up. Stick to these. I mean it. Unless the judge says no, and then you need to file your own thing, just do this. There's one for misdemeanors. There's one for felonies. There's one for. There's some other documents I'm going to mention later that are also on the Washington Court Forms website. Stick to those. I do include this in the presentation though, because I mentioned, hey, it's really straightforward. It's a checklist, and I think it is important to show you that what this looks like. It is a 3-page motion for the misdemeanor one. I think the felony one might be 2.5 pages. So I just include this as an example. You can see the motion here, section 1. It's 1 paragraph long. Defendant's asking for the court for an order to vacate their conviction of a misdemeanor or gross misdemeanor. It cites the RCW. And then here's a section for the declaration. This is the thing I say it should take you 10, 15 minutes to fill out. This will tell you if something's eligible. I, the defendant, state as follows: on blank date, I was convicted of whatever the charge is. Now, there are four sections for check boxes. Should clarify these four check boxes are all things that are exceptions that make something ineligible or might make it ineligible. So, ideally, you don't want to have to check any of these. Is it an excluded offense? Well, if you go down here, section 2.3 is excluded offenses. Excluded offenses are things that are not eligible. So, if you check that box, your order's not getting signed. What's an excluded offense? Sex offenses, violent offenses, DUIs. Also, operating a railroad while intoxicated. Not something I've seen so far, but I'm really excited if I will see it on someone's record someday. 2.4 says prior offenses. Just so that you know what a prior offense is a horrible legal term because it makes no sense. A prior offense is something that was charged as a DUI and then was modified to something else. Every time I've seen this come up, it is a DUI where the client took a plea agreement that had it changed to usually reckless driving. Uh, if that is the case, if you have somebody who has a DUI on their record, but it was amended to another charge, that is a prior offense. There are a few extra rules involved. The biggest one is that has a 5-year waiting period, not a 3-year one. But if that's the case, look at those check boxes. And then there's a section about domestic violence misdemeanors. If somebody has multiple domestic violence misdemeanors, they're not going to be eligible to vacate. That does come up occasionally. There's a section 2.5 explains that. And then there's a whole section about folks who are convicted of crimes related to prostitution with sex trafficking involved. Honestly, having looked through the rules on this and having had it come up a few times, I don't see that makes any difference in the actual process. If you look on the Washington Court Forms website, there is also a section of forms about vacating marijuana convictions. As far as I've seen, there is absolutely no benefit to using those forms over these ones. They don't apply any additional benefits to the client. They don't do anything. I'm going to talk a little bit about Blake, which is going to change some things further. But just to show you, this form shouldn't take you more than 15, 20 minutes to go through. That's it. So what does the paperwork look like that you're going to file for a misdemeanor vacate? Well, first of all, you're going to need to file a notice of appearance. It says, I am the attorney for this motion to vacate. This is all associated with whatever the existing case number is. So this may be an ancient case. You're going to file that motion and declaration to vacate a misdemeanor conviction. That form I just showed you that's on the Washington Court Forms website. They also have an order that goes with it, also on the Court Forms website. And depending on which court you're in, you may need to set a hearing, either a notice for hearing or a note for motion or a note for hearing, whatever they call it in that particular court. A lot of times, this is not actually necessary. A lot of courts, they will just do these by agreed orders or the judge will just review them. But depending on where you are, you may need to set a hearing just to get a judge to look at it. Usually, like I said, usually not getting much argument from anybody because they're just so low stakes for everyone else involved. Let's say you have somebody with a felony. What does the paperwork for a felony vacate look like? This, again, all on the Washington Court Forms website. I have templates for all this stuff if you need it. Notice of appearance, the motion and declaration for the felony form, the order for the felony form. And here's the one twist for felonies. There's something called a certificate of discharge. When somebody is convicted of a misdemeanor and they get their sentence requirements of your 6 months probation, pay $500. If they do their 6 months of probation and they pay their $500, the court clerk will probably make a note in the docket saying, it's all paid. With felonies, there's actually a piece of paper folks are supposed to get that says this person's done everything that they were obligated to do, and that is called a certificate of discharge. If somebody completes all their sentence requirements while they're under probation or while they're still involved with the Department of Corrections, the Department of Corrections sends them a certificate of discharge that says, hey, you're all done. However, if somebody completes their supervision, their probation, and they haven't completed all their obligations, Department of Corrections goes, well, we're done. And they never get that certificate of discharge, even if they complete the obligations later. This is the majority of folks with felony convictions, because what happens is they get a day in jail, 6 months probation, and a $2,000 fine, and they don't pay off that $2,000 fine in 6 months. They may never pay it off. And because of that, they never get a certificate of discharge, even if they pay it off later. So you should also be filing, if there's no certificate of discharge, a request for a certificate of discharge. And if that person did like an anger management course, you may need to file some exhibit that says they did this. I also find there's lots of circumstances where there is no paperwork for any of this. So all you're saying is, well, I have my client sign a declaration that said they did everything. For felonies, it's very common that you're going to have to request a certificate of discharge. Also, these are all on the Washington Court Forms website. Don't get twisted up in this, because the certificate of discharge form has a lot of stuff that's like, I've included copies of everything that's happened in my client's life, and that's the proof that you need. My experience is most prosecutors and most judges, they just look at the court docket and go, oh, it says they paid off their last fine. Great. If it don't get in the weeds trying to request copies of all this stuff. Just talk to the prosecutor, talk to the judge, file your motion, and have your client say, yeah, I did it all. Especially if the conviction's from 30 years ago and the court records have been destroyed. This is all you got. And again, you might need to set a motion. You might need to set a hearing. Sometimes you do, sometimes you don't. I'm going to speed through this. The only thing I want to stress is you're going to have to file the motions. You're going to have to serve them on the opposing party, which is going to be the prosecutor. Just to clarify, there's no formal service necessary because you are filing motions on an existing case. That also means there should never be a case filing fee or any sort of service fees. These should be zero cost processes. I have seen a few courts try and charge people upwards of 200 some dollars for this, as though they were filing a new case. If you see that, send me an email. I will get someone to yell at them, and then that will go away. Has been my experience. But just so you know, you should not be paying anything to do this work. And then you get the judge to sign the order. What do? I mentioned this already, but you send a copy to the Washington State Patrol. They have an email address for their records department. You verify the court records are updated. I usually wait a few weeks. State Patrol takes some time. They have a customer service line for their records department that I will say has been really pretty good. If you call and say, hey, can you look up here? I'm the attorney for this person, and here's the case number. They will actually tell you, like, oh yeah, it's gonna take us a couple weeks, or they'll say, yes, we've entered it. It was entered on this date. And I've actually had them check the FBI records as well to make sure they're up to date. Then you give the client the good news. And if they have a bunch of stuff on their record, you start on the next conviction. It's important to tell the client the good news, because part of the benefit is they can now tell employers, oh, I don't have a conviction. I was never convicted. And it's important they know that, because that is sometimes the most confusing part. Is it feels like they're going to have to lie to an employer and say, no, I don't have any convictions. It's their legal right to do so. So what's some tips? Let's see if I can go back one. I'm going to take a very brief break after this. I don't know how well I'm doing on time, but I want to make sure you guys have a clear understanding of LFOs. But before I do that, here are some tips from the practice of this. One, this is the biggest one. Ask to vacate multiple convictions in the same court at the same time. So let's go back to that hypothetical Amanda. She's got 20 driving with license suspended convictions from Seattle Municipal Court. Your expectation may be, okay, I'm going to draft the paperwork and talk to the client, and I'll file one, and then I'll draft the paperwork for the next one and file that. Don't do that. Even if it takes a long time, draft 20 sets of paperwork, one for each case number, 20 notices of appearance, 20 motions to vacate, 20 proposed orders, 20 notes for hearing if you have to, and you file all of those on the same day. And the reason for this is, having talked to prosecutors and clerks and bailiffs, the work that the prosecutor needs to do and the work that the judge needs to do is they're going to go pull that client's background check, pull out some information about them, and look it over and go, oh, this person looks like they're eligible. They don't have an open warrant. They don't have any recent convictions. I don't see any legal fines still out there or whatever. And then they're going to go and say, okay, well, let me look through these 20 identical motions, sign, or I don't object to any of these. And then it goes to the judge, and the judge is going to do the exact same thing. If you file these all spread out over a period of time, Prosecutor's going to have to do that 20 times. The judge is going to have to do that 20 times, and they're not going to like you for doing it. The other thing is if you have to set a hearing, that means you're just setting one hearing, and the judge is going to just go down the line and say, oh, I'll vacate all these. This one, I need more paperwork, whatever. The additional factor to that, the second tip is if you have somebody who's got a felony where they still owe money and they never got a certificate of discharge, but maybe they can waive those LFOs, you should be filing the certificate of discharge and asking to waive LFOs and asking to vacate the convictions also all at the same time. So you're going to have a ton of you can potentially have just an enormous amount of paperwork that all is getting filed on the same day. But if they're in the same court, if they're going to be reviewed by the same judge, do those at the same time because that's the exact same. You are consolidating the work the other parties and the other people involved have to do. They're going to be much more likely to give you what you're looking for, and it's going to save you a lot of time because you're just going to show up potentially for one hearing, maybe for no hearing. Maybe you'll just get an email from the judge saying, I've signed them all, here's 20 PDFs. Lastly, and this one's important just as a, hey, if this comes up, feel free to email me. So here's a hypothetical. Somebody gets charged with theft in the third degree, and maybe it's their first time they've ever been charged with a crime. They have a defense attorney who says, oh, because this is your first one, we can take a plea agreement where a variety of things can happen. One thing that might happen is a deferred prosecution. This is a very common type of plea agreement where somebody says, okay, I plead guilty, but if in 6 months I've done X, Y, and Z and paid my fine and taken my class and don't have any new convictions, the court will come back and dismiss all the charges. Super common. The problem is in that 6-month period, this person's pled guilty and that case is just sort of in a holding pattern. Washington State Patrol gets a notification that this person has pled guilty to case number XYZ, and that goes on that person's watch report. And then later, 6 months later, the client says, okay, I've done everything I need to. The prosecutor and their defense attorney and the judge says, great, it's dismissed, all good. And then Washington State Patrol gets a notice from the court saying, oh, this was dismissed. And what they do is they go on the watch report and say, this person pled guilty to theft in the third degree, and then it was dismissed. And then an employer later gets a notice from their background check company that says, this person pled guilty to theft in the third degree. The reason that I note this for folks is 50% of the time, maybe, when you go make a motion to vacate that conviction and you're in front of that same judge who did the plea agreement, what they may tell you is, I don't think I can vacate this. This isn't a conviction. It's all dismissed. You can vacate those convictions. I have case law and briefs to do it. In my experience, the prosecutors never fight these issues. It's the judge who will be like, I don't know if I have the authority to do so. They do. You can make that argument. You can win that argument. But this does come up occasionally where somebody thinks they've taken a plea agreement that will solve this problem. And they may have been told by their defense attorney, the prosecutor, and the judge, just do everything we say and this goes away. And then they find they can't get jobs anymore. So just something to look out for. I have a brief on it. I can help you with this. Okay, I got 21 minutes left. I'm going to speed through legal financial obligations. This is the new part of the presentation, so please let me know feedback you have. What are legal financial obligations? So that is just a blanket term for any sort of legal fines and fees that happen when somebody is charged and convicted with a crime. These are broken out into a couple different categories that are important to know. This is sort of the vocab for this. There are a section of legal financial obligations, a section of LFOs called mandatory LFOs. Those include restitution, the victim penalty assessment, and the DNA collection fee. I put parentheses because if somebody may be charged, it's like $100 in King County Superior Court, I think it's $100. They may be charged the DNA collection fee every time they are convicted of a charge. They're only one of those is mandatory. If somebody's been charged $100 6 times, one of those $100 charges is mandatory and the rest are not. The other thing to sort of stress here is conceptually, not literally, but conceptually, these are the restitution and victim penalty assessment are meant to be fines paid to somebody who's been wronged as payment for the wrongdoing. In reality, that is very rarely the case, but I think that is why these are considered mandatory, why they're treated more seriously, is because in theory you're paying someone back for the harm you did to them. Generally speaking, you're probably paying an insurance company or some, I don't know, a company that's gone out of business. There's all kind of garbage with this. There's also another thing called discretionary costs: court fees, public defender fees, jury fees, appellate costs, court stuff, not going to a victim conceptually, just going to a court. Those are the things that are the easiest to waive. And then lastly, we need to talk about when you're asking to waive LFOs, what the court is going to want to know is your client low income? Are they indigent under the legal definition? And there's a lot of different things that make someone legally defined as indigent. Easiest one, if they are under 125% of the federal poverty level, it changes year to year. So you probably want to look that up before you do this. They're indigent. If they receive public benefits, which also very common, they're indigent. If they're involuntarily committed to a mental institution, they're considered indigent. And most importantly, for most of the people on this call, if they are being served by a qualified legal service provider, by a legal aid program listed in the Washington State Bar Association's QLSP list, they're indigent by definition. And that's going to be important here when I get a little later into it. So you got someone coming to you, maybe they're asking to vacate a conviction, or you just look at their record and they've got all these legal fines. Well, what can you waive from somebody's LFOs? This breaks down depending on where they are. If they're in superior court, there's a limited set of things that can be waived. And if they're in a court of limited jurisdiction, generally speaking, if they're charged with a misdemeanor, if that's the conviction you're looking at, or a gross misdemeanor, there's a lot more you can waive. If you're in superior court, here's what you can waive: interest on non-restitution LFOs. So if they have a bunch of interest because they have all these public defense fees or appellate fees from 20 years ago and it's just been piling up interest, those can go away. If they have interest on restitution, that can go away if the principal's been paid. You may find in a lot of circumstances where this does not come up, but if somebody is ordered to pay $1,000 in restitution in 1998, and that is compounded interest for 20 years, that they may have a lot of interest that can be repaid, that can be waived if they've made $1,000 worth of payments. If they've paid enough to get rid of the principal, the rest can go away. Any sort of discretionary or appellate costs can be waived. And this one's important: if the person was assessed fines prior to July 1st, 2000, based on the date they're released from total confinement. So if somebody's been in jail for 20 or 30 years, maybe this won't apply. But otherwise, prior to July 1st, 2000, those fines are on a deadline. Those expire after 10 years. And the state has the opportunity within those 10 years to extend it another 10 years. But if it's not, those fines have expired and they are just can all be thrown out as in totality. The other thing I should say is, because it's prior to 2000 and it's a 10-year period and they can be extended another 10 years, if you see somebody with a conviction prior to July 1st, 2000, it's a good chance they can probably waive all those LFOs because it's been more than 20 years in time. Unless that person was in jail for a number of years, probably eligible to waive it all. And then the last thing is the State v. Blake decision, which I'm going to cover on its own slide. So we'll get to that. Now let me talk about courts of limited jurisdiction. So if somebody's got misdemeanors and gross misdemeanors, or you're looking at municipal court or King County District Court, what can be eligible to be waived there? Basically everything. There are exceptions like DNA collection fees. I don't see those very often. I don't know. Majority of the time, if I am in a court of limited jurisdiction and somebody owes fines, it is the judge's discretion what to waive, and they can waive everything. The prior to July 1st, 2000 rule also still applies, but generally speaking, my experience has been, if you can make a convincing argument to the judge and the judge is open to the idea, they can waive everything. Also State v. Blake, which I'll talk about again. So, State v. Blake. This is from, I don't know, 3, 4 weeks ago. The Washington Supreme Court declared that simple possession is an unconstitutional law. So, folks who were convicted of a variety of drug possession charges, those convictions are no longer constitutional. So, what does that mean for the work you're doing? Now, I will say this is 3 or 4 weeks ago. I'm still learning. The courts have not really dealt with this issue all that much, but I'm going to tell you what my understanding is. I know I have folks from my office in this presentation as well. They probably know more about this than I do. But the important thing to note is if you look at somebody's record and you see drug possession charges or violations under the Controlled Substance Act convictions, most likely that person is eligible to, not even eligible, that most likely that person is required to have that conviction vacated it because it's an unconstitutional conviction, have all their LFOs waived because they should never have been assessed fines on an unconstitutional law, and third, the court is obligated to refund them any legal financial obligations they've been paid. Now, there are a variety of other consequences of this that I'm probably not even competent to talk about. In theory, well, not even in theory, people need to be resentenced because maybe their sentences have been changed by all the possession convictions on their record. Um, I have not yet seen a court refund anyone a dime yet, even though they're obligated to do so because they're afraid where's that money going to come from. But so many people have possession convictions on their records. So the key thing to keep in mind is if you see one of those, vacatable, fines are waivable, they're owed a refund. Uh, it's we're going to see how this shakes out in process, but these anything that falls under that category is going to be its own thing, and basically the way to look at it is they should never have been convicted, so that person should be uh, getting a pass on all of that and any fines they've paid. So let me show you a hypothetical just to give you a sense of how my brain works. I've got two things here. This is a redacted version of somebody's record that shows some legal fines. Um, so I'm looking at this person's record. This is from a program called JABS, which is what prosecutors and public defenders use to look at somebody's complete record within Washington with a lot of the information cut out of it. Just so you understand what these columns are, here's the court it was in, here's the second column's the date, then here's what the charge was it a domestic violence related charge, what was the judgment. So here's what I'm doing as somebody who's done this work for a while. I look at this list and I see, okay, in that last column, there's 1, 2, 3, 4, 5, 6 legal fine balances listed on here. I look at the first two, and I see under the judgment column, this JG, the judgment is a C, which means committed, which means it's a traffic infraction. These are not convictions. There is stuff you can do around traffic infractions, but it's a very different process than waiving legal fines. It's kind of based on whatever court you're in, whatever they do. But these are like municipal charges. Okay, I go down a little bit. I see on 3/7/2013, there is what LKM, which I think is Lake Forest Municipal Park. Maybe it's Lakewood Municipal Park or Lakewood Municipal Court. There's a balance of 1,070.60. So that's a court of limited jurisdiction. That's a misdemeanor. Most likely those fines are eligible to be waived in their entirety because it's a limited jurisdiction court. And then I go down and I see S27, which I think is Pierce County Superior Court. I see at least three sets of fines that are for 965, 793, and $14,000 and 708 or $14,785. Those ones, it's going to be a question of is that restitution and the victim's penalty assessment, or is this interest, or a mix of both? Maybe there's some stuff that can be waived, maybe not. I also look through here and I go, okay, none of the convictions from before July 1st, 2000 have any fines listed on them. So that probably doesn't apply here. And I don't see any drug possession charges. So State v. Blake doesn't apply. Okay, so what's that look like to me then? What am I thinking if this is a client asking me, hey, what can I do about my fines? The infractions can't be waived, or at least not waived under the process we're talking about here. That would be one of those things where it's like, well, maybe we can make an argument to a judge, but it's going to be down to like city codes. There's a Lake Forest Municipal Court case. Well, again, court of limited jurisdiction, so it's all waivable based on the discretion of the judge. So that's worth a shot. I see S27, Pierce County Superior Court. So interest, non restitution interest, court fees, restitution interest if the principal's paid, those might be waivable. Basically, I need to do more investigation. But the one thing I'll say from doing this in experience is those aren't round numbers on there. So there's probably something I can waive on there. So what do I mean by that? Well, if you look at that Lakewood Municipal Court case, the charge is $1,070.60. Nice big round numbers with a lot of zeros. That is probably a combination of a $500 charge and a $500 charge and a $70.60 charge. Probably not a lot of interest accruing. But when I see numbers like 965 and 25 cents, that gets my brain going. There's probably interest there, or the person's made some payments, or something has made those nice round numbers the court loves so much not round anymore, which means there's probably waivable stuff in there. Either they've made payments on the principal, or there's interest, or there's weird fines and fees. I also see there's two cases in S17 down at the bottom, that assault in the third degree and assault in the second degree, that says balance not applicable. That's because King County Superior Court doesn't play nicely with jabs when it comes to legal fines. So I'll probably need to get more info either from the client. Hey, have you been getting collection notices? Have you been making payments to King County? Do you remember being charged anything? There's some more info I have to collect. Maybe I need to go to the court and get case documents. But basically, looking at this, I can go, there's probably fines that can be waived on this list if this person is indigent, which they are if they're coming to talk to me at my legal service provider. So, what does the process of that look like? I know I'm getting right up to the end of time here, so I'm going to speed through this. Washington Law Help has a pretty good packet that I think was included in the materials on how it's a pro se packet. So there's probably info if you're an attorney that you don't need. How do I waive legal financial obligations? They're specific to district and municipal court, but the forms are going to be kind of the same. What are you going to need to file? Notice of appearance, a motion to waive or reduce LFOs. There's a financial declaration you can and probably should modify. There's one included here. There's also a Washington Court Forms version of these. I don't like them. Don't use those. Proposed order and maybe a notice for hearing, similar to a motion to vacate. What's that process look like? You draft them, you file them, just like with the motion to vacate, serve and talk to the prosecutor, talk to the clerk about what the process looks like, and set a hearing. Now, here's the caveat. Here's the difference between waiving LFOs and vacating convictions. When you vacate a conviction, most likely the prosecutor is going to either agree to it or just say, I don't care. I'm not going to object, whatever. It's up to the judge. And the judge probably is going to look at it and go, either this person's record, it looks fine and I'm going to vacate it, or they're going to go, I don't know, this person's got a lot of domestic violence cases and I hate those. So I'm not going to vacate it. That's kind of as far as those arguments go most of the time. But the difference in waiving LFOs is I have found a lot of judges really want you to make a pitch. They want you to know, well, why should this client not have to pay anything? Oh, what's going on in their life? Don't they have a job? This is where you, as an attorney, will probably have to argue about why this is important to your client's life. That's the first tip I have here. This is discretionary. Even in Superior Court, this is more discretionary. Sometimes I will find the judges are willing to waive a lot of the interest stuff. Some of that stuff does not have as many discretionary impacts on it. But if you're in municipal court or district court, be prepared to give a talk about your client. If you're volunteering for a QLSP, your clients are legally indigent. This can be a way to avoid a lengthy financial declaration where your client has to list out, here's all my fines and fees, and here's what I pay each month for whatever, which then becomes part of the court record. It's uncomfortable, it takes a lot of time. Depending on which court you're in, this may not fly, but I have found writing a motion that says, this person is served by my program, which legally makes them indigent, is enough for some judges to go, okay, we'll move on to why that's important. And like I said, this is going to come down to how persuasive you can be about your client's life in the maybe 5 minutes you get. This is, you need to make an elevator pitch. This is not going to be a long, drawn out argument. Prosecutor may not say anything, but I have seen judges, lots of judges say, oh, well, shouldn't they pay the court? Don't they owe this money? What about all that restitution that should go to Target where they shoplifted? This is where you need to make your, this is where it's up to you to convince them. And last but not least, ELAP needs you. Our lap needs you. All the various laps need your volunteering, because we have thousands, tens of thousands of people who have legal fines they can get waived, convictions that can be vacated, things that are posing barriers to them that with a little bit of your time, a few hours really, you could make a huge impact on their life. And it's just really a hard process for folks to do themselves, because so much of it involves being able to argue to a judge why someone's indigent, for example, being able to call a bailiff on the phone and get them to tell you, oh, sorry, this needs to be moved over. Really hard for somebody to do for themselves. And last but not least, I don't have much time left, but I've talked for too long. I've got 4 minutes left to answer questions. And there's my email address if you need any information about this. If you want any templates or briefs, or you just have questions, feel free to reach out to me. I'm always happy to talk to folks about this. Let me see. I have a very helpful comment from Janet. The balance column does not include interest. That is the balance of the total fine, costs, and assessments opposed on the judgment and sentence. So if in that case, you should be, I mean, you should be finding out what the balance someone owes is by probably calling the court, or finding looking at a copy of the docket, seeing if there's been payments made, um, get it going to the financial page and getting some info that way. But I still have found that to be a very helpful way to judge whether there are, if I see nice round numbers, I usually think, okay, these are probably fines that have been assessed. And when I start seeing smaller numbers and cents, it can be a sign. Unless people have other questions, I think that's the presentation.
Okay, thank you so much, Jacob, for your presentation. I put Kim's email in the chat if anybody is interested in reaching out to ELAP for volunteer opportunities. Thank you so much. If you don't have any more questions, I'll stay on for a few more minutes, but otherwise, have a wonderful afternoon.
Yeah, thanks for having me. Thanks to Macy and Kim for bringing me in.
Of course.